good afternoon, or good evening, depending on where in the world you're watching this from. My name is Sunita Advani, and welcome to the third ArbChat interview session. For those who are new to ArbChat is a virtual interview series founded by Ipek Ince, Francis Chung, Vishal Aggarwal, and I as Young ICCA mentees, and supported by our mentor, Lijun Cao, and our group advisor, Elizabeth Chan. ArbChat aims to facilitate intellectual exchange and knowledge sharing between the experienced and younger generations in arbitration. In each session, we interview global thought leaders in international arbitration to raise awareness of topics in this field about which we are passionate. Today, we have a very special guest with us, who is none other than our mentor and prominent counsel and arbitrator, Lijun Cao of Zhong Lun Law Firm.
Yes, so perhaps I will introduce Mr. Cao first. Mr. Cao Lijun is an equity partner and co-head of dispute resolution at Zhong Lun Law Firm. Before joining Zhong Lun, he was a former deputy director at China International Economic and Trade Arbitration Commission, CITEC, foreign-related department in Beijing. As an arbitration counsel, Lijun represents and advises clients on different arbitrations in China, Hong Kong, Singapore, and also other jurisdictions. During his practice, Lijun has represented clients in over 200 arbitration cases on different subject matters, such as international sale of goods, joint venture, equity transfer, energy and mining, construction, and also intellectual properties. His clients are mainly multinational companies, foreign invested enterprises, private equity funds, large state-owned enterprises, and also private enterprises. Lijun has been recognized as a leading lawyer in China-related dispute resolution by various legal directories, including Chambers and Partners, Who's Who Legal, and also China Law and Practice. Since 2004, Lijun has also arbitrated over 150 cases as presiding arbitrator, sole arbitrator, or party-nominated arbitrator in mainland China, Hong Kong, Singapore, and also London. So perhaps we can get started with our interview, Lijun. So if any participants would like to ask Lijun any questions, please feel free to type your questions in the Q&A box below, and we will raise them to Lijun in the Q&A session later. So I know that Sunita has a question to Lijun in relation to your background. So please, Sunita.
Yes, our first question is, how did you develop an interest in practicing law, and in particular in practicing arbitration?
Well, let me first say I wish to thank Sunita, Francis, Ipek, and Vishal. They are all the mentees in this mentoring program at Young ICCA. Well, for coming up with this excellent idea of ArbChat, and also for inviting me to play a part in this interesting program. It's truly my honor to be here today. Going back to Sunita's question, well, I started my career as an arbitration practitioner from 1995, right after my graduation from UIB School of Law. Back then, I started my career with CITEC. As Francis mentioned, it's China International Economic and Trade Arbitration Commission. It's #1 arbitration institution in China. And in terms of case load, it's still one of the leading institutions on international arbitration across the world. So the reason why I joined CITEC is because back then, several of my professors at UIB Law School, they were CITEC arbitrators. They frequently mentioned about the arbitration work they have been doing at CITEC. So I became interested in arbitration. So that's why.
Talking about CTEC, Lijun, could you share with us more about your experience there and how would this experience be conducive to your practice as arbitration counsel later on?
I have been working at CTEC from 1995 to end of 2008 and beginning of 2009. During the 13 years time, I played the role of first as a case manager for almost 10 years, and then as a department deputy director for 3 years also. So the basic role is to assist tribunal with cases. It's more like what we call tribunal secretary these days. It's different from the case manager in other institutions outside China, because back then we assist the tribunal to draft arbitral awards. That proved to be very helpful for my later career, because at that time there was a practice of having case managers like us, like myself, to assist with drafting legal documents, particularly the arbitral award. That practice has been criticized by some international experts and later abandoned by CTEC. But back then, I helped assisted the tribunals in drafting at least 200 awards. And they give directions, the sole arbitrator or presiding arbitrator, they give direction to myself. And after I finish the draft, he or she will read it carefully and revise it and tell me how to revise it. So I truly learned a lot. Back then, there were only 200-300 arbitrators. They are all leading scholars and practitioners from China and from across the world. So I truly learned a lot from this experience. In around 2008, that's right after the economic downturn, there are many disputes. So I got invitation from some law firms. Eventually I decided to join Zhong Lun, which was a national firm and was building up its arbitration practice. I think it's the right choice for myself. So I have been working with Zhong Lun since then. The work at the CTEC proved to be very, using your word, conducive, because the institutional work at CTEC provides me with the perspective of how to handle the procedural matters from an institution's perspective. But assisting the tribunals helped me to gain understanding of some typical substantive law issues. And I got to know the mindset of those leading arbitrators when tackling the substantive law issues. So after I became a counsel, when I discuss with my colleagues or my clients about those procedural or substantive law issues, I frequently share with them what the institution or what those leading arbitrators may deal with those issues. That's a very different perspective, cannot be easily earned if I'm only doing the counsel work from the beginning of my career. So that's how I think that this experience help with my career development.
That's truly very insightful, Lijun, to learn that it's not just about putting pen to paper, but also learning about the thought behind the pen.
Yes.
And coming to our next question, you are an immensely successful arbitration practitioner at a large Chinese law firm with a global footprint. What is your vision for arbitration in China, and what do you want your legacy to be?
My legacy. Well, I still think myself to be quite young as a practitioner. So it's probably too early for me to talk about the legacy. But anyway, I think me and the practitioners of my age in China, we are basically the first generation of arbitration practitioners that go abroad and do arbitration, do overseas arbitration. In the 1980s and probably also the 1990s, there were a few China-related cases in overseas arbitration, but the number was small, and the chances for Chinese lawyers to handle those matters are minimal. But in the past 10 to 20 years, things have changed. You know, we have sufficient chances to handle overseas arbitration. At the beginning, we are only playing the role of a bridge between client and the overseas co-counsel. Basically, we were supporting the overseas co-counsel in those arbitration proceedings. But gradually, we learned from our co-counsel and we gained the experience. Nowadays, I will say starting from 10 years maybe, but definitely from 5 years ago, we are doing arbitration by playing a leading role by ourselves, particularly when the governing law is Chinese law. So if you ask me what my vision would be, I think in the process, we learned how international arbitration are to be handled. We also learned, we enhanced our understanding of international arbitration procedure. We try to import those knowledge to China, try to bring our colleagues in China who do not do international arbitration more insights about overseas or international arbitration. You know, Chinese arbitration law is being amended. If you take a look at the draft amendment, you will see it's not far away from UNCITRAL model law. So that means to say the arbitration system is being internationalized. So I think the mission, I wouldn't say legacy, the mission for my generation is to help more practitioners to become interested in international arbitration, help them to go abroad to do overseas arbitration, help the entire arbitration law system in China to be internationalized. So it's some sort of I would say it's a national need for China to be engaged in the world. You know, the arbitration system in China also needs to be internationalized, and our arbitration practitioners also need to be fully engaged in the international arbitration at large.
Lijun, I must say it's extremely inspiring to learn about your career trajectory, how you look at it as not as a legacy, but as your mission, and how you have shouldered the responsibility of imparting the knowledge of arbitration to the next generation of lawyers who are interested in arbitration. I'm going to slightly briefly drift into a contemporary issue, and I want your views on the same. In the background of Russia-Ukraine war and its impact on global supply chains, what are the areas in international disputes that you think will be on the rise in the near future?
Well, I think the Russian-Ukraine war only happened at the beginning of this year. A lot of things need to be seen. I know my colleagues who are doing compliance work, they already have cases caused by the war. But for international arbitration lawyers, particularly international arbitration lawyers from China, haven't seen any case caused by maybe the supply chain disruption caused by the war so far, but I'm sure there will be cases. Only thing is that it remains to be seen from the perspective of a Chinese lawyer. I think a similar situation is that the pandemic also caused supply chain disruption. In the past 3 years, we have seen sufficient cases in relation to the pandemic, to the supply chain disruption. In those cases, issues such as force majeure always come into play. And from the Chinese law perspective, there's also issue of change of circumstance if force majeure cannot be established. Well, from the Chinese perspective, I probably can share some observations about the recent trends, the rise and fall of cases. We do see in the past few years the disappearance of joint venture disputes or shareholder disputes. I wouldn't say disappearance. Disappearance is probably not the correct term, but we see much less joint venture disputes in the past few years. That's probably because some foreign investors are pulling out of outside China, outside mainland China. That's why there are less number of joint ventures and therefore less disputes. On the other hand, there are increasing number of international sales of goods disputes, increasing number of distribution agreement disputes, and increasing number of license of technology disputes. I wonder whether these are the two sides of the same coin. That's because, although international companies, they are withdrawing from China, there still needs to be a way of doing business with the Chinese counterparts. Those transactions that previously was concluded through their joint venture or subsidiaries in China are now concluded through their overseas entities against the Chinese counterparts. So that's why there are a flow of goods leading to international sale of goods disputes or distribution disputes. There's also a flow of technology leading to licensing disputes. That's the trend in relation to China-related disputes in my own perspective and observations.
Yes, Lijun, you're right in saying that it seems that different eras will have different types of arbitration proceedings will come up. But as a junior lawyer or junior advocate like us, it seems that some skills are transferable in handling different types of arbitration proceedings. So according to your years of arbitration experience, what do you think are the do's and don'ts for a good arbitration counsel, especially for a junior advocate like us?
Do's and don'ts, those are classic questions. Well, maybe I can come up with a few suggestions for the junior arbitration lawyers. For the do's, in my view, things that junior lawyers need to do is, number one, to find the right team and the right mentor. Only each firm has its arbitration team, and the arbitration teams may be different, and the cases they prefer to handle are different. So when you have an interest in developing arbitration career, you need to find the right team and find the right work, right? And the right mentor is also important because some mentors, some partners in the law firm, they are very careful in developing its team. So they paid a lot of attention to the development of young talents, and they give a lot of opportunities for training. Some partners, they may be busy with work, focus on work, rather than spend much time on the training of junior team members. So some partners they will provide sufficient opportunities for the trainees or the junior lawyers to study abroad. That's totally different. So you need to find the right team, right partner, right mentor. That's advice number one. And number two, use the best efforts. Try to become as good lawyer as you could ever be. When you have an assignment on a particular case, use your best efforts to accomplish the best results. Only through this, you can gain the confidence from the other team members, particularly from the more senior team members. you will have more chances, more opportunities to handle what in your view would be interesting or good cases. And number three, I would say patience, be patient. A lot of, I have trained junior associates for the past 12 years. I have trained over 20 junior lawyers. I can compare them and see those successful young lawyers who later have opportunities to become a partner. They truly are patient. Some young lawyers, they may not be patient. They want to do big cases. They want to have more exposures. That's always not going to be very successful because, well, in China, we call the law as a social science, right? As opposed to, natural science. For natural scientists, it depends on, whether he's smart enough. Some genius scientists, they may come up with an idea overnight, that others may spend the entire career to prove, may still cannot come up with such an idea. But for social science, for lawyers, everything needs to be developed gradually. You need time to gain your knowledge. You need time to gain your expertise and skills. You need time to build up your connections. So everything have to be developed step by step. So it's truly important to be patient. As for don'ts, I think it's similar things. If you are patient, you wouldn't be jumping from one platform to other platform over a short period of time. I try to give advice to all my younger colleagues not to change their job in 3 years. So without 3 years on the same platform, you cannot fully understand that platform. You cannot gain all the benefit that that platform can provide you. So for each job, at least 3 years. So do not change your job in 3 years' time. And the other thing is, I don't know whether you would like to hear this. Do not spend too much time on the social network. It's helpful. It can help you promote yourself, and you can make friends. You can get to know some recent development about a particular law area, but it's not that helpful. It's not as helpful as you expect it to be. I don't think the client will look for you on those social network. In China, we have a WeChat group. It could be 500 people, all arbitration lawyers, but not everyone is equally busy. So if you spend too much time on that, I don't think it's very helpful. Sometimes I see some arbitration lawyers, they talk about a particular legal issue in those groups. Seems to be quite professional. But when you come across such lawyers in real-time arbitration, you will see that they are not paying attention to their contract clauses. That's I was very disappointed to see that happening, and from that moment of time, I think truly we should avoid using too much time on social network.
Thank you, Lijun. That was really helpful. And I would like to follow up on the advices to the younger generation and ask you one more question on that.
Yes.
As you know, arbitration is just a method for resolving disputes, but what makes you win the case is the substantive part. So do you think, especially the younger practitioners, should prioritize deepening their knowledge on the substantive law over procedural law?
I think young practitioners need to pay attention to both. It's not to prioritize one thing over the other. Procedural law is important. That's how you distinguish yourself from the litigators. Some litigators, when they have a chance to handle arbitration, you will see that they do not truly understand the procedure, because for arbitration, the procedure matters are truly complicated and truly important. If you do not handle it carefully, you are risking the outcome of the arbitration being denied enforcement. So that's truly a big risk. But on the other hand, all the arbitration cases, they are disputes over substantive law issues. So you need to understand the substantive law issues, not just procedural issues. So procedural law is necessary. It's very important, but that's not everything. It's not sufficient. So you have to, learn both at the same time. So that's my advice.
Thank you, Lijun, for that. Following up on the question regarding the procedural and the substantive law, we have seen that international arbitration as a dispute mechanism has proliferated into different areas, whether it is construction, oil and gas, mining. So we as a younger practitioner often feel confused whether is it better to develop a niche early on in the career and developing in international arbitration, such as any sector such as construction or oil or gas, or as a junior practitioner, should we try our hands at all the kinds of disputes before making a choice whether to specialize in one particular area?
That's a very interesting question. My suggestion is to do everything at the beginning years. The truth, the reality probably is that you do not have that much choice. If you are really in a law firm, in a team, you just do what your superior, what your partner asks you to do. And that's probably not to be your choice. Over the years of time, you may develop the niche by yourself. So for example, if you repeatedly handle construction disputes, you may develop an interest in construction disputes. If you have the interest, you probably will try to develop this expertise, because you think about the same issue twice, you probably come up with a better idea. If you do that frequently, you are better than your other colleagues of a similar age experience on this particular area. Then the others will notice that you already developed this interest or even the expertise. So your partner will note that you have this expertise, and the client may note you are doing better on this kind of cases than others. So you get recognized for this area. Then you probably want to start with another area and develop another expertise. Speaking for myself, I myself regard myself as a general commercial dispute lawyer rather than a lawyer with some particular area. That's useful because if you identify yourself as a construction lawyer or oil and gas lawyer, maybe the other cases, the clients will not look for your service. You only have construction law cases or oil and gas cases. Speaking for myself, I do not. I did handle a few construction cases as the earlier years of my career, but I think it's not that interesting for myself because it appeared to be quite fact intensive with very thick case files, but the law issues, the legal issues involved are not that complicated because the construction contracts, the FIDIC contract or otherwise, they appear to be quite detailed and well drafted usually. So there would not be too many complicated legal issues to be dealt with. But for oil and gas, I did handle quite a big number of oil and gas cases. I would tell my clients, my peers that I have a sufficient experience handling those kind of cases, but I do have quite a wide scope of expertise or practice. That's probably better for my business, honestly speaking.
Thank you so much, Lijun. Last question is from me before we move on to the questions raised by our audience. Because new areas of law popping up quite relatively these days, there is this constant feeling of FOMO, fear of missing out. For example, we feel like we need to be experts on cryptocurrency disputes, artificial intelligence, etc. Do you think it is that really important to catch the train early on, or arbitration lawyers can always find a way and we should not be stressing about keeping up with the latest trends?
Well, honestly, I do not know much about artificial intelligence disputes. There were debates about whether in the future artificial intelligence will replace international arbitrators as decision makers. So that's quite interesting debate. I have seen such debates for at least twice at important conferences. But for cryptocurrency disputes, that's really happening. I do not do much study in this area, but it happens that I currently have two cryptocurrency disputes at hand, and they are all to be resolved through CX arbitration. But that's an truly interesting trend. But if you ask me for advice, I would say most of our work would still be traditional disputes. Maybe one day AI dispute or cryptocurrency dispute will become a traditional dispute. But for now, it's new cases, and there are not plenty of such cases. So what we do to support our business or to support our career is basically through traditional disputes. And there are plenty of such disputes for arbitration lawyers. So I would say that there is no need to keep up with the latest trend. All you need to do is to have do good work, try best efforts to become an excellent arbitration lawyer, and so that you can get plenty of traditional disputes. We don't need to catch the new trend. As long as there is a trend, that you will be brought to the destination. So old trend is good enough for that purpose.
All right.
And thank you so much, Lijun.
All right. We probably have some Q&A questions which are lined up, which are quite interesting. I mean, I would also advise other audience members to please send in their Q&A questions. So the first question that we have from our audience is regarding entering into the Chinese legal market. So, Lijun, what do you think you would advise a Chinese and a junior lawyer who's trying to get into the Chinese disputes without having without being belonging from China or having some ethnical affiliation with China? So what kind of advice do you give to such junior advocates?
Well, the difficulty is always about how to get your first case. For in this situation, is how to get your first China related case. Well, I think it's important to to show the understanding of the Chinese culture, and maybe also the corporate culture of a particular Chinese company if you want to get a case there. But sometimes you will be handling case against a Chinese company. That's also considered to be China-related cases. If you have such experience, it's also helpful and convincing when you are approaching a Chinese potential client for a potential matter. That can show your experience handling similar matters. But at the same time, I think try to get the first case even if it's not a big matter, even if you are not paid well. So if you get a first case, you start to accumulate relevant experience, and then you will have the second one and the third one, and you will be better paid. So you gradually build up a recognition among the Chinese users or Chinese clients. Also, I think client visit is very important. Nowadays, we are in pandemic. There are lots of travel restrictions. It's not so easy to travel to and from China. But in the old days, I believe after the pandemic over, it will be the same situation. It's important for international firms to travel to China, to Beijing, Shanghai in particular, to meet with potential clients and also meet with colleagues. One of my friends is an in-house lawyer with one of the 3 big oil companies in China. He said it's truly important to visit them because, if you visit them 2 or more times, he will remember you. He probably will have easy access to your business card or your email address, your contact details. So if he has an urgent matter, which happen to be from your jurisdiction, he will very likely to look for you, particularly when in that matter, his company is a respondent in arbitration or defendant in litigation. He will look for you and it will become your case. That happened a lot in practice. So I think that's why I think client visit plays an important role in bringing your potential work.
Right.
I hope this is
Right. Lijun, we also have another question, which is a junior lawyer. We have always been told to just put a lot of effort on your work and your work is going to speak for yourself. But when you're part of such big organizations and dynamic teams, we often come across situations we have to deal with some sort of, mind my words, but office politics. So what suggestion would you have to the junior lawyers in how to deal with such situations, how to deal with conflict of interest in those situations, and how do we go about it?
Well, office politics. Politics is everywhere. So for law firms, because honestly, we are lawyers. Lawyers are political animals. So there are very pretty much office politics more than other organizations. But working in a law firm of hundreds of lawyers or thousands of lawyers, and there are always complicated political issues in the organization. So I would say office politics is not specific for junior lawyers. It's for senior lawyers, for partners, and even for the management of the organization. So it's nothing that we can easily avoid. But for the junior arbitration lawyers, I think the important thing is to, number one, is to do good work. And number two is to get along well with your colleagues. And number three, not to try to gain your promotion through other means. Only try to gain your promotion through the exercise of your professional capabilities. If you do all the 3 things, and there are still politics which negatively affect you, you should not care. You should, if you get all 3 things done, that means you are doing everything fine. Everything should be in good order. But human nature, sometimes if you are a good lawyer, your colleagues who are not spending as much time as you on the work, he or she may feel jealous. He may start up rumors against you. That will happen. That will happen sometimes. But so you should not care too much. That's others' problem, not your problem. You should not punish yourself because others are mistaken. Okay, that's my suggestion.
Thank you, Lijun. Now that I see that we don't have any more questions in Q&A round, I would pass on to Ipek to do the closing for the session. Thank you, Ipek.
Thank you so much, Vishal. Lijun, thank you so much for taking your time and answering our questions. As your mentees, it was definitely an unforgettable moment for us, but I'm sure it was as delightful as it is for us, our audience. Thank you so much again, and thank you so much for your responses as junior lawyers. We really appreciate that, and hopefully we will see our audience in the next episodes of ArbChat. So please do not forget to follow us on LinkedIn and also on YouTube.
Thank you, Ipek.
Thank you.
Thank you, everyone.
Thank you.
Take
Thank you.
care.
Bye. Take care.
Bye.